How do you analyze res ipsa loquitur in your negligence analysis on a tort essay question? Well, remember we said your negligence analysis is going to be centered on 4 elements: duty, breach, causation, and damages. And thus far, we've been focusing primarily on the first element, which is duty. Remember whether the defendant owed the plaintiff a duty to conform his conduct to a specific standard of care. Once you complete your analysis of that first element of duty, you answer that question, you're ready to move on to the second element, which is breach, which is going to be the focus of today's video. Whether the defendant breached the duty of care that was owed to the plaintiff. So the good news about breach is, once you complete your analysis of duty, this first element, your second analysis of breach should be pretty easy most of the time. All you have to do when you get to breach, once you've already determined whether the defendant owed the plaintiff a duty of care, and you know what that duty of care is, you've identified the standard of care that was owed, once you get to breach, all you have to do is compare the defendant's conduct in your fact pattern, your defendant's conduct, to the standard of care that was owed. And if your defendant's conduct meets the standard of care owed, then there's no breach, no negligence. However, if your defendant's conduct in your fact pattern falls short of the standard of care that was owed in your duty analysis, then of course you're going to have breach, and then you can move on to causation and damages. If you have all 4 elements, the defendant can be held liable for negligence. So usually your breach analysis is going to be very fact specific, and it's just going to ask you to draw a comparison between your defendant's conduct in the fact pattern and to the conduct that was owed that you established under this first element of duty. You just compare that conduct, the defendant's conduct in your fact pattern, to the conduct that was owed that you determined in your duty analysis. Again, that can usually be done in 1 paragraph, 2 paragraphs tops, and then you're moving on to causation. So breach as an element is usually going to be a pretty easy analysis. You've done all the hard work in your duty analysis, okay? Now, the one time where breach can get a little bit trickier is a situation where you don't have any direct evidence as to what the defendant's conduct actually was. If you have a fact pattern where you have an accident that results in harm, and it's the type of accident that ordinarily does not occur absent negligence, so it's obviously, it looks like negligence, it smells like negligence, it feels like negligence, but you don't have any facts that directly show how the defendant was in fact negligent, how the defendant actually breached the duty of care owed, then you're probably dealing with a res ipsa loquitur situation. And you can see how this could happen in real life. Imagine that you have a plaintiff who's injured in some type of accident and is knocked out cold, can't remember anything about the accident, there's no witnesses there, and the defendant isn't volunteering any information. So we have a situation where we have this accident, maybe it does look like negligence, but the plaintiff can't actually provide any facts that show direct evidence as to how the defendant breached. So imagine what's going to happen in that situation. Let's just flesh this out a little bit more. Plaintiff sues defendant for negligence and doesn't plead any facts of direct evidence of a breach. What do you think the defendant is going to do in response to that action? Probably file a motion for directed verdict. It's going to say, hey judge, you can view this evidence in the light most favorable to the plaintiff all you want. Plaintiff isn't providing any evidence of the breach. So how can you find that a reasonable jury could possibly hold me liable? And that judge might agree with the defendant and say, well, look, sorry, plaintiff, you didn't present me any facts that show direct evidence of a breach. I'm going to dismiss your action. Well, res ipsa loquitur is a way that the plaintiff can avoid this type of dismissal, this type of directed verdict. Plaintiff can say, hey, look, judge, okay, maybe I don't have any direct facts, any direct evidence as to exactly what the defendant did to breach, but we can infer negligence from this situation. Res ipsa loquitur, the thing speaks for itself. The Latin translation of res ipsa loquitur, by the way, is the thing speaks for itself. And this is basically coming from this situation where the plaintiff is saying, I don't have any direct facts, but this type of accident, how could this occur absent negligence? And if the judge agrees, And if these three elements are satisfied that we're going to talk about in a minute, that plaintiff can avoid the directed verdict, and ultimately it's going to go to the trier of fact to decide whether the defendant was liable. Note right here that this is different than negligence per se. If we establish negligence per se, and remember we talked about 5 elements, if those elements are established and we have negligence per se, in most jurisdictions, that means the defendant can be held liable for negligence as a matter of law. If these elements are satisfied and we have res ipsa loquitur, that's not establishing negligence. That's just a way of basically avoiding a directed verdict. It's a way of putting forth circumstantial evidence that the fact finder can consider. So a big procedural difference we need to know in our heads before we move on. But to illustrate res ipsa loquitur a little bit better, what it is, how to apply it, let's look at one of the first cases that ever applied this doctrine of res ipsa loquitur, and that's Byrne v. Boadle. This case comes from the 1800s. I think it's around 1863, and it's one of the first courts that ever applied res ipsa loquitur. So again, I'm going to do a horrible job of drawing a fact pattern, but I'm sure most of you anyways remember this case. But if you don't, just to refresh everyone's memory, remember we have Boadle's flower shop. So here's my little flower shop. It's a 2-story flower shop. Here's a door. Let's put some windows on the 2nd floor of this flower shop. And remember, the employees at Boadle's flower shop are trying to lower barrels of flour to the ground. Now remember, we're in the 1800s, so no advanced machinery. They're just going old school rope and pulley system. So they got a rope and they're lowering barrels of flour to the ground. And while this is going on, we have Byrne, the plaintiff, minding his business, just walking down the street. And of course, as he's walking beneath this flower shop, Boadle's flower shop, out of nowhere, somehow a barrel falls out of the 2nd floor of Boadle's flower shop and hits the plaintiff. Of course, this causes a lot of injury. He's hit by a giant barrel of flour. He wants to recover damages, so he sues Boadle's flower shop for negligence, and that's how we get Byrne v. Boadle. So the problem here for Byrne is he has no direct evidence as to how this barrel fell from the 2nd floor of Boadle's flower shop. He doesn't know exactly how it happened. He has some witnesses who did see the barrel fall and hit him, but nobody knows how the barrel fell. So the trial court says, hey, look, there's no direct evidence of breach, so they side for the defendant, Boadle's flower shop. No direct evidence of the breach, but of course that gets appealed, and we end up with this doctrine of res ipsa loquitur, where the court on appeal says, you know what, maybe there's no direct evidence of a breach, but we know that this barrel didn't magically grow little legs, walk out to the window, and jump on Byrne. We know something had to happen to dislodge this barrel. It didn't magically fall from the sky. It didn't grow little legs. Barrels of flour don't just roll on their own and hit people, right? Something had to happen. So because we know that something had to happen, we can infer some type of negligence. The thing speaks for itself. Res ipsa loquitur. So that's how we get this idea of res ipsa loquitur, this doctrine that allows you to infer some type of negligence from the circumstances, okay? And so over time, we've developed 3 elements to establish res ipsa loquitur. Number 1, the accident resulting in harm was of a kind that ordinarily does not occur in the absence of negligence. So here we can say the accident was of a kind that ordinarily does not occur absent negligence. Number 2, the accident resulting in the harm was caused by an agent or instrumentality within the defendant's exclusive control. So here the accident was caused by an agent instrumentality within defendant's exclusive control. Okay, and then finally your third element is going to be that the accident resulting in harm was not due to any action on the part of the plaintiff. Okay, so here we can say, and basically this third element is just saying that the plaintiff was not contributorily negligent. So the accident was not due to any action of P. Okay, so here's your three elements. And I think the best thing to do is just to kind of apply these three elements to Byrne v. Boadle and see what happens. Okay, so was the accident resulting in harm in Byrne v. Boadle, of a kind that ordinarily does not occur in the absence of negligence? And here, this is the whole idea that barrels of flour don't just grow legs and jump out of buildings on their own, right? Something had to happen. This ordinarily is not going to occur but for some type of negligence, right? So your first element is going to be satisfied. Okay, you can move on. Was the accident resulting in harm in Byrne v. Boadle caused by an agent or instrumentality within the defendant's exclusive control, within Boadle's flour shop's exclusive control? Yes, this was obviously caused by this barrel of flour that hit Byrne was obviously within the defendant's exclusive control. No one else had access to the second floor. It was all within Boadle's flour shop. No one else could have messed with that barrel. No other agent or instrumentality outside of Boadle's flour shop had access to these barrels. So we know that what caused the injury was within the agents and instrumentalities were within the control of the defendant, right? What caused the harm was within the control of the defendant. So element number 2, satisfied in Byrne v. Boadle. Finally, we can ask whether the accident resulting in harm in Byrne v. Boadle was it due to any action taken by the plaintiff? Was Byrne in any way contributorily negligent to his harm? Here again, Byrne is just walking down the sidewalk minding his own business. He has no idea that any of this is going on. Maybe he can see some guys loading or unloading barrels, but in no way could he possibly foresee that a barrel was going to fall out of this window and hit him, right? He doesn't have a duty to, I think, avoid that. I don't think that you would find him contributorily negligent for walking down a public sidewalk minding his own business. I mean, arguably, he could have seen these barrels being unloaded and tried to walk around it, but I really think that's weak at best. So here I do think that you would have all three elements satisfied, and that's kind of where we get the idea of res ipsa loquitur. So on a tort essay, if you see a fact pattern like this, where you have an accident resulting in harm, but you don't have direct facts as to what the defendant's conduct actually was, you're going to want to run through these three elements. And as you do that, I would think back to Byrne v. Boadle, because this is a great illustration of what res ipsa loquitur is really meant for. This type of situation is what you want to be looking at, okay? So as you run through these elements, kind of compare it and think about it to this falling barrel case, Byrne v. Boadle. And if you do that, you should be able to kind of establish whether res ipsa loquitur is present or not. And remember, from a procedural perspective, just because you satisfy these elements, that doesn't mean the defendant is liable for negligence. It's still going to be an issue for the trier of fact to decide. All that it's going to do is allow us to make an inference of negligence. Procedurally, you can now avoid a directed verdict if you're the plaintiff. You can avoid having your cause of action dismissed for not presenting direct evidence of breach. Okay, so I know that's a lot of information, but that's the main idea of res ipsa loquitur, and that's really all we need to cover on breach. Remember, normally, res ipsa loquitur isn't going to be at issue in a tort essay question. Because think about it, is a tort essay creator really going to write an essay that gives no facts as to the defendant's conduct? Probably not, but I have seen it, so we're talking about it. If you do see a situation like that, you know res ipsa loquitur. Okay, but normally in your breach analysis, you're going to have facts as to what the defendant's conduct actually was. And if you have facts as to what the defendant's conduct was, all you do in your breach analysis is compare those facts to the standard of care that was owed, which you determined in your duty analysis. You compare those two things and you come to a conclusion as to whether or not there was a breach. If the defendant's conduct met the standard of care that was owed, then there's no breach. If his conduct fell short of the standard of care that was owed, then you're going to have a breach and you're going to be ready to move on to causation, which is going to be the discussion of our next video. But until then, guys, I wish you all the absolute best and I'll see you at our next video.